Welcome everyone to today's webinar, 5 Easy Steps to Prepare Your Parents for Long-Term Care While Protecting Their Assets. We thank you for attending. This workshop is being recorded and all participants will receive a link to the recording within the next few days. My name is Patricia Clay and I'm the Director of Operations and Client Services here at Terabella Law Group. With the overload of people on the internet, sometimes screens can freeze up, so we appreciate your patience should this happen. If you have any questions during this webinar, please enter them in the question box. And if your question should not be answered during this webinar, we will be sure to respond to it by email within 24 hours. And finally, John will be offering a special gift to you, so stay till the end to hear about this gift. Again, thank you so much for attending, and without any more delays, I'd like to welcome John Hilton.
Well, thank you, Patricia. Hello, everybody. Welcome. So my name is John Hilton. I'm a dad, I'm a husband, a son, and I'm also an estate planning and elder law attorney. And thank you so much for being here today. I am really honored to be able to spend just a little bit of time with you. And I'm really excited about today's topic, 5 easy steps to prepare your parents for long-term care while protecting their assets. My hope for you today is that each of you comes away from this workshop with the peace of mind that comes with knowing that there is hope, that your parents can be well taken care of, and that they will not have to spend all of their hard-earned money for that care, should they someday need it. And I invite you to stay with me to the end, because I want you to know that your time today is well spent. And I will be presenting a special offer for just for those of you who watch this entire presentation. And before we get any deeper into this discussion, what I would like to do is share with you some of the experiences our clients have had working with us. So this is Sharon, and she said, it's an amazing experience. Wish I had done this sooner. Keep giving your amazing service. And then this one, they didn't give their name, but they wrote to us and said, making an appointment with you guys was fast, gave us information on what to expect at our first meeting. The staff and support group is beyond excellent. During our several meetings, everything was explained in detail, and if we didn't understand, questions were always answered to our satisfaction. And during the shelter in place under COVID, our welfare was always utmost on their minds. So before we get started, let me first of all acknowledge what I believe is a truth for every one of us. We do not want to ever see our parents in need of long-term care. We do not ever want to see our parents forced to live in a long-term care community. And you may have even promised your parents that you will never let them live in a nursing home, that you will move them into your house and care for them yourself before you will ever let that happen. And most of us feel that strongly about it. But here's the brutal reality. Caring for your aging parents may not be feasible for you. You might be in the middle of a career that you simply cannot afford to abandon without doing harm to your own spouse and children. You may not have the strength and the personal health to take care of your aged parent. Your parent may have a physical or medical condition that you don't have the skill and training to care for, even if you do have the time. And these are the realities we're going to address today. If your parent needs more care and attention than you are able to provide, this is what it will cost them. And these are the average cost per month in Arizona. So for a nursing home, the average cost for your parents to be in a nursing home right now is around $7,000 a month in Arizona. Remember, these are average costs. Many nursing homes are much more expensive. And if you want your parent to be in a nice facility, in a nice community, it's going to be much closer to $10,000 or $12,000 a month. The average cost of an assisted living facility is anywhere from $3,500 to $5,000 a month. And the average cost of a home caregiver at, the average fee right now for a home caregiver is $25 an hour. At $40 an hour, you're looking at $4,000 a month to have somebody come into your home 8 hours a day, into your parents' home 8 hours a day to care for them. Now, let's look at some sobering statistics. The National Clearinghouse for Long-Term Care Information reports that 70% of Americans who live to age 65 will need long-term care at some point in their lives. And over 40% of them will need nursing home care. The MetLife Market Survey of nursing home, assisted living, adult day services, and home care costs reports that on average, someone age 65 will need long-term care for 3 years, and 20% of them will need more than 5 years of long-term care. The Insurance Information Institute reports that 45% of long-term claimants are under the age of 65. Let's repeat that. 45% of long-term claimants are under the age of 65. That means that nearly half of the persons needing long-term care developed an illness or injury requiring that long-term care before they even turned 65. And yet, what we also know is that only about 10% of the population has long-term care insurance. That means that about 90% of the population is at risk for having to pay for long-term care from their life savings. So again, when we think about those costs, the average cost of a long-term care community or a nursing home is $7,000 a month. The average cost of assisted living facility, $3,500 to $5,000 a month. Just to bring a caregiver into your parents' home for 40 hours a week, the average cost is about $4,000 a month. And 90% of the population, meaning 90% of our parents out there, are at risk for having to bear the burden of that cost out of their own assets. So when we talk about how our parents will pay for their nursing home, for assisted living, for a home caregiver, there are essentially 3 pots of money available to them to cover these costs. And those 3 pots of money are long-term care insurance, which we just saw only about 10% of the population is covered under long-term care insurance. They have their own personal resources, or they have the option of Medicaid. Now, when we talk about long-term care insurance, if your parents did not purchase long-term care insurance, when they were relatively young, it's expensive. And for many people, depending on the type of policy that they purchased, it may not even cover the entire cost of their care. And we know that only about 10% of our parents have even purchased long-term care insurance. So again, they're looking at having to pay those costs, $7,000 a month on average out of their own pocket. So let's talk about how do they pay for it out of their own pocket? Well, if your parents do not have long-term care insurance, or if their coverage is not adequate to cover those costs, then the next pot of money available to them will be to use their own resources to pay for their care. And this includes things like their cash, their investments, their retirement accounts, and worst of all, possibly even their home. Now, if you think about the math and their use of personal resources at anywhere from $4,000 to $7,000 a month, that's going to quickly drain your parents' personal assets. We're looking at $7,000 a month, and again, that's just the average, and that's not one of the really nice facilities, but just an average facility in Arizona, $84,000 a year. And you can see how easy it is in just a few months or a few years that your parents' entire life savings could be used up paying for their long-term care. So the other option is to use this a federal and state benefit. It's available to everyone, and it's called Medicaid. Medicaid will pay for much of their health care, but if planned correctly, will also allow them to protect their assets from being depleted. Now, this often brings up the question, well, isn't Medicaid for poor people? Well, the answer to this question is that Medicaid is actually an umbrella term. It covers numerous programs, including health insurance for the very poor. But Medicaid also has programs specifically designed for paying for long-term care. And most importantly, the federal government has passed numerous laws, and the state of Arizona has adopted these laws that allow your parents to take advantage of the programs of Medicaid while still protecting their assets. In Arizona, we call this the Arizona Long-Term Care System. You may have heard of this being referred to as ALTEX. And let's be realistic. If your parents have to pay for their long-term care out of their own resources, they will likely be counted among the poorest of the poor within a short period of time. When we look at that $84,000 a year on average, if your parents, if you want your parents to be in a nicer facility, you're easily looking at $120,000 a year out of their savings to pay for that care. But without the intervention of Congress, and Congress, having passed these laws, so your parents would have to use up all of their financial resources and become financially destitute before Medicaid would step in and help cover the cost of long-term care. So our state and federal governments have given us these tools, these laws that we can use, completely legal. They're laid out in the Arizona, pardon me, they're laid out in the Arizona Medicaid manual. And these laws allow your parents to hold on to their hard-earned assets and still receive financial assistance to cover this heavy financial burden of long-term care. And even though it's perfectly legal, some people still argue that it doesn't seem ethical to, quote unquote, take money from the poor. The reality is, though, that Medicaid long-term care funding is made available to everyone, not just the poor. And it's no different than taking advantage of the tax laws Congress has given us to reduce your tax burden, or estate planning laws to reduce or avoid death taxes. Long-term care Medicaid planning is Congress's effort essentially to provide long-term care insurance for the 90% of the population that's not covered under a commercial long-term care insurance policy. And Congress passed these laws to prevent your parents from having to become financially destitute simply because they need long-term care. Now, also, when we're talking about Medicaid, it's very important that we differentiate between Medicare and Medicaid. Medicare is designed to cover the cost of hospitalization and doctor's visits. And if your parents purchased Medicare Part D, it can help defray the cost of their medications. Medicaid, and more specifically in Arizona, ALTEX, is designed to help cover the cost of rehabilitation after Medicare stops paying. It pays for certain like in-home care expenses, for extended rehabilitation, and for long-term skilled nursing care. For that reason, to qualify for Medicaid, your parents will need to demonstrate medical need as well as meet Medicaid's income and resource requirements. Now, here's the thing. Medicaid representatives, they do not sit down with your parents and explain how to get Medicaid qualified. They take the application that your parents submit and they make a determination based on the information your parents have provided, which, while your parents are probably really careful to provide accurate information, it may not necessarily be correct from a Medicaid perspective. So let's take a look at how your parents may qualify for Medicaid. So again, in Arizona, we refer to Medicaid for long-term care as the Arizona Long-Term Care System, or ALTEX. And to qualify medically for Medicaid, your parents will need to be age 65 or older, or if they're a disabled widow or widower, as young as 50. And they must have a physical disability. And in order to determine that, Medicaid will actually do what we call a pre-admission screening assessment. And what they're looking for are things like, on this assessment, do your parents have emotional or cognitive dysfunction? What are their communication and sensory skills affected? Are they incontinent? Are they able of performing the activities of daily living? There are a lot of many other areas that Medicaid looks at on this pre-admission screening assessment. But the first hurdle is they have to pass this assessment, and Medicaid has determined that your parents are medically in need of some type of care under the Medicaid system, under the ALTEX system. And that may be home care, it may be nursing care, or skilled nursing care. Medicaid makes that determination. And I think it's important to note here that, the Medicaid system nationwide is, their focus is on trying to keep your parents in their home for as long as possible. And so if your parents qualify medically, Medicaid would really like for them to be able to be cared for in their home by caregivers, home health, and things like that. So once they have been determined to be medically qualified for Medicaid, the next step is their income at a level that would allow them to qualify financially for Medicaid. Now, I mentioned earlier, many people mistakenly believe Medicaid is only for people with very low income. And this is really not the case. For example, if your parent is single, then they can have no more than $2,349 a month in countable income. If your parents are both still living, that income limit is even higher. For many people who are on Social Security and maybe a small pension, they fall under the maximum income limit. Many of your parents will not. That does not mean that they cannot qualify under the income rules. So Medicaid looks at income in two different ways. They look at earned income and unearned income. And you can see on your screen examples of earned and unearned income. But the key here is to know not what is so much earned and unearned, but what is countable income, and how to properly calculate income to meet the Medicaid requirements. And when calculating countable income, your parents would need to know what deductions they can take, what allowances are available, and how to legally allocate any excess income to bring their income down to the maximum allowed under Medicaid rules. And all of that is possible and perfectly legal and perfectly ethical under the Medicaid rules that Congress and the state of Arizona have given us. So the third step, after we look at medical need and income, is Medicaid will look at what resources your parents have. And Medicaid defines a resource as items of real or personal property, including cash, which may be used to meet the customer's needs for food or shelter. This is important. Resources must be reviewed to see if they are actually available to meet the customer's needs. So when Medicaid is doing a resource evaluation, they're going to look at all these things on the screen. For example, if your parents have a prepaid burial policy, it may or may not be counted as a resource available to your parents. If your parents are running a business and they have business property or business assets, Medicaid may or may not consider those available to meet the customer's needs. They may exclude them, they may not. If your parents are married some of those resources can be allocated to the other spouse. So you can see on your screen, all of these are types of resources that Medicaid will look at, but it does not necessarily mean that if they have these resources that they will be disqualified from Medicaid. Now, let's assume for example, that Medicaid allows your parents to have a home and they have an equity of about $300,000. And that's well below the Medicaid limit of $595,000 of equity in a home. But that's not the end of the inquiry. Other questions will then come up, including whether your parents intend to ever return to the home if they are in a long-term care facility, whether one spouse will continue living in the home. If there's an adult child who's been living in the home and caring for the parents, that may make that home not available, not countable for your parents. The good news is that within each of these rules that Medicaid applies, and there are many and they're complex, but within these rules, there exists an opportunity to legally and ethically use the rule to your parents' benefit. Now, for every asset, every resource that Medicaid looks at for your parents, there are exceptions and exclusions that may apply. So when applying for all text for your parents, this is where many times you'll find your parents make a mistake because they don't know how to identify the exceptions and exclusions when they submit their application. But remember, the Medicaid representative is not going to explain these rules to you or your parents. They're not going to help you find alternatives to help them qualify. Instead, what happens, your parents are going to receive a letter and it's just going to say denied, period. No help, no advice. We see this all the time. The client will tell us that they already applied for Medicaid and they were denied, even though they didn't seem to have as many assets and they're living on Social Security. So, the good news is that that is still not the end of the story. When you work with a qualified elder law attorney, we know how to get into those rules and apply the law to help find these exclusions and these exceptions that Medicaid has provided for us to help your parents qualify. Now, let's get in to these 5 easy steps. And the first one is, as a child of a parent that you're looking at that you're thinking that, mom or dad, maybe their memory is starting to fail, or physically you're noticing changes in their gait or their health, and you're thinking, man, I can just see, they're probably going to end up having to have some kind of long-term care, maybe care in the home, maybe it's a home caregiver, maybe they're going to need to go into assisted living where they can have some assistance there, or maybe, as a last resort, you're foreseeing a day when they may end up having to go into a skilled nursing community. So the first thing we have to do is actually start talking to our parents about it. And there are 2 scenarios that you may want to consider when speaking to your parents about planning for long-term care. And the first and most immediate is if one or both of your parents are facing immediate or near-term need for in-home or skilled nursing care. You see it just over the horizon. In this case, an immediate plan could start saving your parents money right away. An immediate plan could prevent them from having to use up their assets paying for care. And this type of planning we call our crisis plan. But the other scenario occurs more commonly, and this is when your parents are elderly, probably in relatively good health, but you and they believe that a need for long-term care may possibly arise in the future. And they want to prepare now to be qualified for Medicaid if they need it later. And they don't want to have to go into that crisis mode at the last minute. So using the tools that Medicaid has provided for us, we can help your parents create what we call a peace plan. Because planning ahead brings us peace of mind. And that's a peace of mind that, down the road, we will not be facing this kind of particular crisis, having a plan in place. Pardon me. Now, with that in mind, do your parents, look like they're going to need a plan, within the next few weeks or months? Or are you looking down the road a few years? Do they need a crisis plan? Or can we start putting in a peace plan, getting things ready now for that possibility in the future? It's really important that as children of aged parents, that we initiate this conversation with them. And the first thing I would say is, before you ever even begin to have this conversation, is examine your own heart and motives. Are you coming into this because you don't want them to spend all of their money on long-term care because you want them to leave it to you? Or are you coming into this because you don't want them to spend all of their hard-earned money on long-term care because they need to have financial flexibility as they go through their elderly years, to not be financially destitute, to be able to continue having the joys of life that sometimes only having a little extra money can buy? Remember, if they use up all their assets on long-term care, they'll get like maybe $100 a month in spending money, and everything else that they earn and all their Social Security, everything is going to go to pay for long-term care. So think about your own motives when you talk to your parents, and come to them with a clean heart. And what I would recommend is that when you start the conversation, explain to your parents that you would never want to meddle in their affairs. You understand that that's private and personal to them, but you care about them, and you want to make sure that they have everything that they need in their elder years. Some of the questions that you might begin to bring up with your parents are things like, if you could not care for yourself at some point in the future, where would you wish to live? And, they may say, well, I was hoping I could live with you. Or, I don't ever want to live with any of my kids, and I don't ever want to be in a nursing home. I want to live in my house forever. And those are valid responses. But it opens the door for you to begin to probe a little deeper. What would be, how would you foresee this if, you weren't able to care for yourself, and, we weren't able to care for you? Then, what would you think about, what options would you foresee? Another question you would ask is, how would you pay for any care that may be required? And have you considered what healthcare choices that you desire if you do develop a terminal condition? Do you want CPR if you end up in a vegetative state, or if you develop advanced dementia or Alzheimer's? What do you want us to do as your children? What kind of decisions do you want us to make? Some additional questions that you might consider are, talking to your parents about what kind of plan they do have in place. Were they one of the 10% that bought long-term care insurance? And, what kind of coverage is it? Are there coverage limits? Are there term limits? Can you, would they mind if you reviewed the policy so you can know what to expect if you need to step in and help them? Have they purchased Medicare? Do they have Part A and B? Do they have Medicare C? Have they purchased a Medicare supplement? And what kind of coverage do they have under the Medicare system? And you might want to ask them, hey, again, we just want to be, available to help. We're worried about you as you get older. We're concerned. We want to make sure that we're doing everything we can to help you, live out the rest of your life how you want to, but we want to be there to help you. And, if we ever need them, where can we find your important papers? And even more importantly, would you be comfortable giving me access to those important documents now, so that if something happens, I know where to find them and I know how to get access to them. That might be a key to a safe deposit box. It might be a key to a safe in the house or a desk drawer. But ask your parents, how can I, be sure that when I need those important papers, I know how to get to them and I have access to get to them. And then you can ask this question: what can my spouse and I, my siblings and I, what can we do to help you if you're no longer able to make decisions on your own? So these are all conversation starters to start talking to your parents as they get into their elder years, about what role you can play to support them as they age and as they may need additional assistance. So speaking of, the last question, how can you help? Here are some ideas to kind of help you begin to plan. So one of the things you can do is talk to professionals in your community about which of these independent assisted living or skilled nursing facilities in your community have the best reputation. You can look at things like their satisfaction scores on their websites, things like that, where they are required to report to the US government and to the state governments. Maybe if your parents are up to it, take them and take some tours of some assisted living facilities or skilled nursing facilities so they can see what the options and possibilities are. And they can see that, if there's an assisted living facility or a skilled nursing community, that they think, if the worst should happen and if I should end up here, I would at least be comfortable here. And you're probably going to find that it's not the $7,000 a month facility. But that would give you a basis then to start the conversation about planning financially. If your parents are staying in their home, in their own home, right now, start looking for ways that you can help keep them there by looking at, how can you prevent falls? Do they have loose area rugs or runners that they could trip over? Animals in the house that could cause them to fall? What can you do to make their home safer and more aging friendly? And then, as much as your parents may resist, consider the personal emergency response systems that would alert you or alert somebody if they were to fall and were not and were injured and unable to regain their feet and move on with their life. I was a paramedic for many years, and that was just one of the worst calls that I would go on, is finding an elderly patient who's been laying on their floor for 2 or 3 days, killed children out of town, trying to call neighbors, and it's just it was really heartbreaking to do that. The other thing you can do is become aware of social service agencies and care management resources now. Don't wait until your parents are in crisis mode. Start educating yourself with what kind of agencies and services are out there that will help you when you need it. aginglifecare.org is one of the places you can go to, and they can direct you on their website to resources in your community. All right, so that's the first step. Start the conversation, start talking to your parents about what they want, what their plan is for achieving their goals, their desires in their elder years. What would happen if the worst should happen to them? They fall, they break a hip, they develop pneumonia, develop Alzheimer's. How can you help? And then educate yourself. What's out there? What's it going to cost? And start figuring out what you have to do. Do you need to get on a waiting list? What are the steps that you need to take to help make sure that if your parents need it, there's a plan in place? Now, the second step is just getting your parents organized. And here we're talking really about their financial resources. In Arizona, there are currently approximately $1.5 billion with a B, $1.5 billion in the Arizona State Department of Unclaimed Property. Most of that got there because someone has died and their family was not aware of an insurance policy, a bank account, some kind of investment or retirement account, and so it was never accessed. And those institutions have no choice after a certain amount of time to notify the Arizona State Department of Unclaimed Property and shift that asset to the state. Where it sits, the state can't spend it, the state can't use it, it just sits there waiting. And this is something that could easily happen to your parents if they do not get financially organized and make sure that you, as their children, know what they have in the event of their incapacity or in the event of their death. So here are some things that you can consider talking to your parents about and helping them get organized. What is their computer login and password? Because that's probably where they're going to keep a lot of that information. Do they pay their bills online? And if so, what is their bill pay information? What are their passwords? Where could you find the last 3 years worth of federal and state income taxes? Do they have investments? Who manages those investments? How can you get in touch with them if you need to step in their incapacity? Do they own stocks or bonds? And if so, where are they located? Where are their deeds to their home or vacation property or any other property, investment property? Where are those deeds located? Where are the titles to the vehicles located? And then gather all this information up, with your parents' assistance. Make it a family effort to get all these financial records. And then my recommendation is that you put them in a binder with tabbed sections. A tab for insurance, a tab for property deeds, a tab for retirement and investment resources, so that you can quickly find the information that you need. Take it a step further. You can put all of these in, for an example, an Excel file where they can be updated easily. So this is actually one of the first steps we take with our clients, because we so firmly believe that having financial and other important documents organized is one of the key foundations of proper planning. And again, at the end of this presentation, I'll be telling you how to get on my schedule and have this discussion at no risk to you or your parents. All right, so that's the second step. Help your parents get financially organized. The third step is to help your parents prepare their incapacity documentation. And this is an area where I find many people are misinformed or have not done adequate planning. I hear all the time from clients, well, I already completed my healthcare directives and I did a power of attorney naming my daughter as my agent. And that's great, I'm so happy. But in reality, much of the time they completed those documents without professional help. And when they do actually need them, those documents can actually do more harm than good if they have not been properly completed. So, and especially when your parents and when you're helping your parents prepare for long-term care, traditional incapacity documents will not work and can actually cause more harm than good. So the first one that we're going to look at are the durable financial power of attorney. Now, a typical power of attorney will prohibit the attorney in fact, what we call the agent. This is the person that if your parents become incapacitated, they've said, if I've become incapacitated and I can no longer manage my financial affairs, then I want my son or my daughter or whomever they name to be able to step in and take care of my financial affairs for me. And that person is called an attorney in fact or an agent. Now, under a typical POA, that agent is prohibited from what we call self-dealing. That means you can't do anything with your parents' assets that would benefit you. This means that if you've named your oldest daughter, for example, as your POA agent, she would not be allowed to create an agreement in which you paid her for services as a strategy to reduce countable income, because that would be self-dealing. So when planning for long-term care and planning for Medicaid eligibility, we have to look at things a little differently. We kind of have to break the mold on your typical power of attorney And we specifically allow self-dealing in certain circumstances, such as specifically Medicaid eligibility planning. And so typically a financial power of attorney, will allow the agent to do everything you see on the screen, pay your parents' bills, if they need insurance, or if they need to change insurance policy, your agent has the power to do that. If you need to buy real estate or sell their personal property or sell their home or sell a vacation home, it gives you the authority to do that. In a really well-prepared power of attorney, it will specifically give the agent, and more often than not, it's you, the child, the authority to do whatever has to be done to help your parents qualify for Medicaid. And that includes allowing you the ability to self-deal or to do something that actually benefits yourself in order to help your parents qualify for Medicaid. I'm going to tell you a quick story about Bill. Now, Bill, he was an 84-year-old multimillionaire, and he was a client quite a few years ago. And Bill had made his fortune trading on the stock market. 84 years old, one day he's in a video store and he meets this 25-year-old video store clerk. And he starts teaching him how to make money trading stocks. After a few months of training this video store clerk, Bill, multimillionaire, gave this clerk $14,000 and challenged him to invest that $14,000 and turn it into much more money. Now, Bill's daughters learned about this $14,000 that Bill gave this video store clerk, and they immediately decided that Bill had lost all judgment. He had lost all capacity to make decisions about his money. And they petitioned the court for emergency guardianship and conservatorship over Bill. Now, in Arizona, guardianship refers to control over the person, and conservatorship refers to control over their financial affairs. So they applied for both. After months of hearings, a lot of money being spent, the court actually granted their petition and appointed one of Bill's daughters as his guardian and conservator. As a result, Bill lost all of his rights to drive, to vote, to determine where he would live, and even who his friends could be. And he lost all of his right to control any of his money. Now, during the final hearing, after the judge had made his determination, Bill stood up and he pleaded with the judge to please appoint anyone other than his daughter. And he explained to the judge that his daughter was a mean and ugly person and had been trying to get control of his money for years. And the judge would not be dissuaded, despite Bill's argument. And he even told the court, I understand you think that I don't have proper judgment anymore, but please not my daughter. She's just after my money. Ultimately, Bill appealed to the Arizona Court of Appeals and then ultimately to the Arizona Supreme Court, and still could not get that ruling changed. And so Bill's life, as he had once known it, was over. He was completely under the control of his daughter. Now, why do I tell this story, and what could Bill have done differently? Well, with some proper pre-planning, Bill could have created a power of attorney in which he named his personal choice for who would control his assets when he was no longer able. And then even if the court decided he needed a guardian, the guardian would not have gained access to Bill's fortune, his multiple millions. Even better, Bill could have transferred all of his assets to a trust and named a successor trustee to manage his financial affairs for him if he became incapacitated. So with a little bit of pre-planning, Bill could have avoided that crisis in his life. So now let's talk about some other documents that your parents should consider. These are what we can often refer to as your advanced healthcare directives. And this is your durable power of attorney for healthcare, your advanced medical directives, your living will. And these documents, when your parents complete these, they will make this, they actually allow your parents to make in advance decisions about who will make medical decisions for them when they're no longer able to, and what decisions they want that person to make for them. So they're laying it all out. This is what I want. This is what I don't want. And then they're saying, you child, often the oldest, or you oldest daughter, the common choice. When I'm no longer able to make these decisions, these are the other decisions I want you to make for me and to advocate for me. In a living will, I think we find this especially when we have clients who are facing dementia or Alzheimer's, you know, making decisions ahead of time. If you're not eating voluntarily, do you want to be force fed? And we have a whole list of things that we go through that we can create plans in advance to ensure that in the event of dementia, that your parents are being treated the way they want to be treated, and there's a plan in place for them. If your parents are in pain, but they can't communicate that pain, what kind of treatment do they want? Do they want to be kept comfortable with narcotics or with other types of interventions? You know, if your parents have a terminal condition, if they have cancer or something like that, and their hearts just stop, do they want to be resuscitated, or do they want to be allowed to die in peace? Do they want to be allowed to die at home, or do they want to be, you know, admitted to hospice or skilled nursing? So these are all decisions that are decided ahead of time and then documented in these healthcare documents. All right, so we've talked about starting the conversation with your parents, getting them to talk to you about this, coming at that with a pure heart and pure mind. We talked to you about getting your parents, you know, financially organized and helping them gather all those documents and making sure that you know where they are and how to get access to them. And we talked to you about getting these incapacity documents completed so that you or somebody that your parents you know, choose can manage their finances and can make medical decisions for them. Now, the fourth step is talking to your parents about their estate plan and bringing up the conversation about why they may want to set up a plan that would allow you as their family to avoid probate, which is inherently court and conflict. So let's talk about your parents' estate plan. There are three possible scenarios. One, they have a will, and that's very common. The second possible scenario is that they have a trust, a revocable living trust, also very common. The third scenario is that they haven't done any planning at all yet. So they either have a will, they have a trust, or they haven't done any planning. Now, this does not mean that they do not have a plan, because the state of Arizona has a plan for them if they don't plan for themselves. But they may not like Arizona's plan. And we're going to talk to you about that here in just a minute. But you know, one of the main reasons is that under the Arizona plan, there's no control over who gets how much of their assets, how they're distributed, at what age they're distributed. It's a very straightforward distribution. And regardless of whether they have a will or they've done no planning at all of this has to go through the probate process. And the probate process is a court process. And let's look at it from two different perspectives. If your parents become incapacitated, then they have to go to the probate court for a process called guardianship or conservatorship, which is I just talked to you about with Bill. And in that process, just like with Bill, the court is going to determine who makes decisions for you, or in this case, for your parents, and who makes decisions about their money, who controls their money, who controls where your parents live. Now, that might be you, it might not be you, because it's really up to the court to decide who's best for that. And so, again, a court process. I've seen, you know, siblings arguing in court over who should be the conservator of mom and dad's money, who should be their guardian. It's a court process that invites conflict into the family. So again, a conversation to have with your parents. let's get that power of attorney in place. Let's get those medical health care powers in place. Let's get an estate plan in place that's solid enough that we know what's going to happen and who will have what role. Now, so that was talking about guardianship and conservatorship. Your parents have become incapacitated. If your parents have died, then that same court is going to be involved in a process called probate. And this means that your family has to go to court, and a judge will decide where your parents' money goes. It may not be to whom they would choose or in the amounts they would choose. If they have a will, then they do get to choose the amounts and to whom, but it still goes through this same probate process. So probate is going to be a factor, whether your parents have a will or don't have a will. The only difference is that if they have a will, they get to decide who gets what when they die. Now, look at the screen and you can see that this is a slow, drippy process to get through probate. It costs a lot of money, and you can see on the screen, there's attorney's fees and executor's fees and bond premiums for the personal representative. Assets have to be appraised, so there are appraiser's fees and court filing fees. Creditors have to get paid. And only after all of that will the beneficiaries or the heirs of your parents' will receive anything. And then this takes time. In Arizona, the absolute fastest we could probably get through this process is 9 to 12 months. Very often it takes up to 2 years to get through this process, during which time your parents' beneficiaries, your parents' heirs are not getting the access to your parents' assets. Talking about the cost, attorney's fees alone in Arizona are going to range, anywhere between $3,500 to $6,000. So then you add on appraiser's fees and all these other fees, and probate can get very expensive. But even more than that, more than the toll it takes on your parents' assets is the toll that it takes on the personal representative, the person that the court appoints to make sure all of this happens, that makes sure that the creditors get paid and that everything is distributed according to the will or according to the Arizona statutes. And I don't know, I can't even tell you how many people that I've sat down with and I've asked them, are they familiar with probate, and how many people's eyes roll and how many people groan and say, yes, I had to probate my parents' estate. It was horrible. It was exhausting. I'm still doing it. I still can't get it closed. It is not a fun process. And it's something that you might want to talk to your parents about. Mom, dad, have you thought about what will happen when you die? Do you have an estate plan in place? Is it a will-based plan? And so do you realize that we're going to have to go through probate? And this is what it's going to be. They may not know. Most people don't know what probate actually involves. So you can have that conversation with them about how to get a plan in place. And I'm going to talk in a minute about how to keep their assets, their estate out of the probate, out of court. So we said, it's expensive. It's really time and energy draining on the personal representative. It takes, at best 9 to 12 months, often as much as 2 years to get it through. It's also public. And that means that anyone can go down to the courthouse and pull your parents' court records to see what they owned and who got it. For example, this is the will of Jackie Onassis. You can see in here exactly who got what in her will. And this is a public access document. All you have to do is go down to the courthouse where it was filed and get a copy of it. I could, pull up the will of John Lennon, JFK Jr., Babe Ruth, Jerry Garcia, all of these left wills that were probated, and we could actually go into the courts and pull those and find out exactly what was in their estate and who received it. So the point here is that a will is public and it does not avoid probate. And I think that's some of the two biggest misconceptions people have. It's public and it does not avoid probate. It will go through the court process. And when a will enters probate, it puts all of the creditors out there on notice that your parents' loved ones were going to be receiving money. That may be you, that may be a sibling. And there is a way, and the only plan that is private, the only plan that avoids probate and ensures that all the beneficiaries receive their assets when at a certain age and in a certain amount, and as a side effect can actually save a lot of state taxes, is a properly funded trust. But we'll talk about that more later. But right now I want you to understand probate process, whether you have a will or don't have a will, your parents' estate will have to go through probate. If they have a trust, completely avoids probate. It's completely private. Another thing your parents might consider is that, especially if your parents are really well off, and you or your siblings, your other beneficiaries of your parents, you can, ensure that when your parents leave their estate to you, they can actually do it in a way that protects those assets that go to you, your siblings, and others from lawsuits that may be lodged against you, from creditors that are after your assets. Even like if you should get divorced, your inheritance from your parents can actually be protected and not be touchable by the courts, by creditors. And most adult children have no idea how to, for example, keep an inheritance separate from their community property. And as a result, they get divorced, and that future ex-spouse is getting half of their inheritance because they haven't kept it separated correctly. But if your parents leave their inheritance for their children, probably you, in a protected trust, then your parents' children can keep all of that, even if they get divorced, even if they file bankruptcy, or even if they have a court judgment against them, their inheritance can remain safe and protected. Now let's talk very quickly about Aretha Franklin. We all know Aretha Franklin. She died a few years ago, and she left behind 3 adult children, one of whom has special needs. He's autistic. And her family, after she died, eventually found 3 different wills. And each of those wills left her multi-million-dollar estate to her children in different amounts. In one of her wills, she even disinherited her son with special needs. Now, because she had a will-based plan, and because there are 3 of them, Aretha's family is going to be spending much of her estate assets fighting in court over which will the court should admit to probate. And then they're going to have to go through the whole probate process. And with an estate that size, it can take years and cost thousands and thousands of dollars. So here's my encouragement to you and my curiosity that I hope you would have about your parents. Talk to your parents about their estate plan. Do they have current wills? Have they been updated recently? Do they have a revocable living trust? And if they do have a trust, have they properly transferred all of their assets into the trust so that the trust will actually work? And when they do eventually die, will your parents' children, will you receive your inheritance outright? Will it be transferred to you in a protected trust that will guard your inheritance from the possibility of future divorce, bankruptcy, or other legal action? And so again, like I said before, in just a few minutes, I'm going to be sharing with you a special no-risk promotion that will allow us to educate and inform you and your parents about what would happen to them under their current estate plan. And we'll show them all their options and show, if they want to make any changes at all, we're happy to help them with that. But at the very least, you and your parents can leave fully educated about their estate plan and how it will affect you. All right, so we're almost to the end, and we have one more step. And this is to actually execute a Medicaid qualification plan now. Instead of waiting for a crisis, instead of waiting for your parents to be admitted to a nursing home, you start working with your parents and with your family to get that plan in place now. Now, you should probably, and I'm going to tell you why, but you should probably consider getting professional help with helping your parents apply for and qualify for Medicaid. And I'm going to tell you why. In 1981, in the case of Schweiker versus Gray Panthers, the United States Supreme Court called the Medicaid laws an aggravated assault on the English language, resistant to attempts to understand it. And then 13 years later, in 1994, in Rehabilitation Association of Virginia versus Kozlowski, the United States Court of Appeals for the Fourth Circuit called the Medicaid Act one of the most completely impenetrable texts within human experience. And they called it dense reading of the most tortuous kind. So, the Medicaid application itself is lengthy, it's detailed, and it's complex. But in addition to the application, and this is where so many families, make a mistake, is your parents will need to submit appropriate verifications and calculations of income, resources, asset transfers, and even then, without proper professional assistance, many Medicaid applications get rejected that should otherwise have been approved. In addition, it's extremely imperative that the Medicaid application actually be submitted at the appropriate time. Submitting it at the wrong time can have disastrous consequences. So my encouragement to you when you're thinking about helping your parents pay for their long-term care and helping them, consider Medicaid as an option and getting Medicaid qualified and using these tools that Congress has provided for us is get professional help. It's well worth the time and investment in getting it done right with somebody who understands these laws. So because every family has different medical needs, they have different marriage and family situations, income and assets are different. There's no one plan right for everyone. And to properly plan for long-term care in a way that protects your parents' assets so that their money can be used to care for them in other ways, besides just paying for long-term care, each family must have a custom plan, including custom healthcare directives, a custom power of attorney, an estate plan is customized to the family's wishes, desires, and values, and a long-term care plan that addresses your parents' specific needs and desires. And in order to accomplish this, we actually offer two approaches. The first and the most desirable is what we call our peace plan. And in the peace plan, you and your parents sit down with us to put a plan in place that can easily be executed in the future if the need arises. If your parents don't ever have to have skilled nursing care or don't need to ever apply for Medicaid because they're not facing that financial devastation of having to pay for it themselves, then this plan just sits there and it's ready for the trigger to be pulled. And if we never pull the trigger, then we move on, and but everything's ready. Now, if your parents have not done any preemptive planning and they do find themselves needing immediate Medicaid assistance, then we also provide what we refer to as our crisis plan. So even if your parent is already in a skilled nursing community, we can still get them Medicaid qualified and we can still protect most of their assets. So what's involved in this Medicaid qualification plan? First of all, it's a comprehensive plan to legally shelter your parents' assets while qualifying them for Medicaid. In order to do that, it requires a comprehensive analysis of your parents' assets to determine which are counted and which are disregarded. And it requires a comprehensive analysis of your your parents' income and your all the income deductions and exceptions that we can take to determine income eligibility. At that point, this plan may include a lot of strategies. Medicaid has given us so many possible strategies to use, but many of them may not be appropriate for your parents and many of them may be. So we have to look at everything individually and see which of these strategies work for your parents' particular situation. If your parents are married, it may include transferring assets between the spouses from one spouse to the other. It may include transferring some assets to a special Medicaid trust. It may include retitling of some assets. It may include spending some of their cash. Maybe they need a wheelchair ramp. So we can spend some of their cash that may be a counted resource for a wheelchair ramp, and now it's no longer a resource. We spent it on the home and the home's excluded, and we can get them qualified. So there are many other strategies. They're all approved by Medicaid that we can use to help your parents qualify for benefits and still protect all of their assets. So one example we have, just very quickly, is we could consider what we call a family caregiver agreement. And in the family caregiver agreement, your parents agree to pay you or another family member a certain amount of money to provide care for them for the rest of their lives once they become incapacitated. Now, this does not necessarily mean hands-on caregiving. That may not be possible. But a family caregiver agreement could be for a case management care, in which if your parents end up in long-term care facility, you agree to attend all the case management meetings with the care staff. You agree to advocate for their comfort and their health care, to coordinate all their ancillary care with the nursing facility administrators. And so with this personal care agreement, that's part of our peace plan, we can draft that agreement, have everybody sign it and lay it aside. Something happens to your parents and they need to go into a long-term care community, we pull that agreement out and we execute it right there, and right then their financial assets get transferred to you legally. It's not a gift, and they can be qualified for Medicaid the next day. And this is laid out in the Arizona Medicaid manual as a strategy. So the key is that that family caregiver agreement must be carefully drafted to meet those state requirements and to ensure that the duties of all the parties are well thought out and well documented. So this is just one of our strategies that the Medicaid system gives us to help your parents qualify for Medicaid when they need it. All right, so now what? Well, my hope is that I provided you with really helpful information, and I hope that I've given you some hope for the future of your parents. Now, I don't want to leave you hanging with unanswered questions. I don't want to leave you wondering just what you're supposed to do next. Now that you know that there are options for your parents that will allow them to have the best medical care and protect their assets in the process. So I would love to meet with you and your parents with no obligation to discuss their options. Now, if you're like me, you're probably wondering, well, why should why should I even consider working with you? I've never met you. You're a voice on a webinar. And before this workshop, I never even heard of you. So why should I work with you? And I wouldn't blame you if you had reservations about that. But what I would ask is that you give me a chance, again, at no risk to you, to just sit down with you and your parents and discuss your concerns. Because I'm not your typical attorney, and I would really love the opportunity to prove it to you. So, I conducted an online search a while back for attorney. I was looking for photos of attorneys, and this is what turned up. And if this is what you're hoping to find in your relationship with an attorney, I can guarantee you, you probably will not want to work with me, because I can candidly say I am not that kind of attorney. First of all, I value my relationships with my clients above all else. I work really hard to develop and maintain those relationships year after year. And I strongly believe in what I do. And I so strongly believe in it that I've built a team of qualified people to work with me to make your plan a reality, to be there when you need us, to provide advice and direction, to answer your questions, and ultimately to ensure that your plan works when you need it the most. And finally, I believe your parents should get value for what they invest in. Make no mistake, this is one of the most valuable investments your parents will make in their lifetime. This planning could save them hundreds of thousands of dollars over just a few years of long-term care. So, unlike many attorneys, I only charge a flat fee for this investment, and there are never any hidden costs or surprises. So, to demonstrate my commitment to my clients, here are what just a few of them have had to say. Vicky Sue said, John is not your typical attorney. He makes sure you understand all legal documents in plain and simple terms. He takes the time to get to know you and is always there to help. It has been a privilege to be his client. And then Norman and Donna said, we found John and Patricia both to be very personable, easy to understand, and helpful. This is most important to me. We feel as if we've known you both for a long time, almost like family. And then Bree said, this has been a wonderful experience while making difficult decisions. I am so glad I was in the hands of John Hilton's group. They were patient, helped me through the process, and guided me through setting up vital next steps in the event my family needs it one day. All right, so you stayed with me throughout this entire presentation. And you stayed with me because you have concerns about your parents and what might happen if they should need long-term care at some point. And I want you to know that you don't have to walk away with more questions and no answers. And I want to make it easy for you to get started getting the answers to your questions at no risk to you or your parents. All you have to do is schedule your free life, legacy, and Medicaid family planning session with me to get started. It doesn't matter, and this is really important. It does not matter where in Arizona your parents live or where you or your other family members live. We love to meet our clients in person, but we can also meet with the entire family wherever they are via teleconference. And particularly, this type of planning can be completed remotely, and we can even notarize their signed documents remotely. So no matter what part of Arizona your parents live, we want to assure you we can meet with them and with you. We can meet with your siblings anywhere you may be. And we can get this planning done. We can get your questions answered and make sure that that everyone, the whole family, is involved and understands what's going on. Now we begin all planning with our clients with what we call a life, legacy, and Medicaid family planning session. And this is a process that our clients, they absolutely love it. And you're going to love it too, because it supports your parents to get more financially organized than they've ever been before. And it helps ensure that they make informed, empowered decisions for the people that they love. So they know what they actually need to have in place and what they don't. And we love it when the entire family is involved in this conversation, because this is truly a family planning session. And during this process, you and your parents are going to actually choose their own fee for the planning they do. By the end of it, they will know with certainty that they are making the best decisions in the event of their incapacity or death, because everything will be so well handled for them. And ultimately, this is something that you and they do for the people that they love. So if you see on the screen, you can see our standard fees for these plans. And for a simple estate plan, whether it's a will or a trust, our fees range anywhere from around $2,000 to $8,000, depending on the complexity of the plan. Again, all flat fees, everything is agreed to in advance, no surprises ever. For our PEACE plan, if your parents are needing to start getting things in place now, in the event of potentially in the future needing long-term care and wanting to qualify for Medicaid, our PEACE plan ranges anywhere from about $7,500 to $15,000. Now remember, this plan has the potential of saving your parents hundreds of thousands of dollars. If it's a crisis plan, if you're calling up and saying, hey, mom's in a nursing home, she's spending $7,000, $10,000 a month on this nursing home, we need to figure out how to stop the bleeding, how to stop this flow of money out of her account. We need to do it now. That's our crisis plan. And honestly, that fee varies depending on the situation that we're looking at. Okay, so hopefully this answers your questions, and hopefully this gives you enough information to know exactly what you're dealing with when you call us. Now, as I mentioned earlier, there's a bonus for staying on to the end, and we've reached the end. So congratulations for sticking it out with me. I really appreciate it, and I've enjoyed it. Now, I typically charge $750 to meet with a client for 2 hours of education and information to empower the clients and the client's family and parents to make the best decisions for their family. But the first bonus that I have as my guest today, and for sticking it out with me, is to get you onto my schedule at no charge. So you can save that $750. And all you have to do to schedule your life, legacy, and Medicaid family planning session with me one-on-one and get started on your plan is go to, you can see it on the screen, tarabellalaw.com/schedule-online. And that'll take you straight to my scheduler. Now, I know that when you listen to a presentation like this and you're thinking about everything, you're thinking about all the possibilities, that it's easy to get excited, but it's also easy to think, I'm just going to wait, I'm not sure. What we know is that the longer you wait, the more life begins to intervene, and the excitement that you feel now, the potential, the hope, the promise that you feel now will begin to fade. And I want you to make a decision, so I want to give you an incentive. If you schedule your meeting before this workshop ends, then we're going to take another $250 off of a PEACE plan that we create for your parents. So you're looking at a 2-hour session, you're going to save $750 because we're not going to charge you for it. And you can save another $250 off your planning if you go ahead and go to my scheduler and get on the schedule now before this webinar ends. Now, remember, the PEACE plan includes everything your parents need to prepare for possible long-term care, including custom advanced healthcare directives, their custom power of attorney, custom estate plan, and their long-term care Medicaid qualifying plan. So the scheduler is open. Look at your calendar, get on there. It's no cost to you. There's no risk. The only thing you're going to spend is 2 hours of your time talking to me. So tarabellalaw.com, schedule-online. Do that before we end this workshop. We've got, I don't know, maybe another 10, 15 minutes, and schedule that 2-hour meeting, and you're going to get $1,000 worth of value from me. Okay, when you go to that scheduler, at the bottom of the page, there's a place for a promo code. On that promo code, in order to qualify for this $1,000 in gifts, type in I attended live at the bottom of the scheduling form. I attended live to qualify for the $750 gift towards the 2-hour meeting with me and the $250 off of a PEACE plan. Now, I only take very limited number of clients every month. My time is very limited. So the appointment slots are offered on a first come, first served basis. So if you want to get in there at any time soon, now's the time to go to terabellalaw.com, schedule online, and reserve your 2-hour meeting with me. Again, no cost to you, no risk, just 2 hours of your time talking to me. And again, do it before the end of this workshop. We'll throw in another $250 discount towards your peace plan. Promo code at the bottom of the page, I attended live. And remember also, doesn't matter where your parents are, doesn't matter where you are, we can do all of this remotely through teleconference. All right, so what's the next step? We just said, next step, schedule your free life, legacy, and Medicaid family session at terabellalaw.com or schedule/online. Or if you can't get to that site for some reason, then you can call the office, 520-428-1188, and speak with our client services director, and she will make sure that you get on the schedule. And when you call, you'll be talking probably to Patricia. Let Patricia know. I tried to get onto the website. I could not get on the schedule. I really wanted to get on. I didn't get on there. Can you get me on? And can I still get that $250 additional discount? I really tried. Let her know. I'm trying to get on there. When you get to the scheduler, at the bottom of the page, type in the promo code, I attended live. And then all you got to do is show up, design your plan, and leave with peace of mind. And I thank you for attending. And I believe we are going to take some questions now. Again, thank you so much for giving me the opportunity to hopefully educate you today about the possibilities that you can help your parents with in helping them plan for their long-term care and protect their assets. So we do have time for questions. And while we're doing this, I want you to check your calendars. Try to get try to get onto my calendar, get your session, your family, life, legacy, and Medicaid planning session scheduled on my calendar. And we're going to take questions, but what we're going to do is Patricia's going to cover some of the most frequently asked questions that we get during these workshops. After that, we'll see if there are any questions in the question box that we did not get to or answer already. So if you have a question, go ahead and enter it in the question box now. If we don't get to it, we absolutely will promise we will email you an answer to your question within 24 hours. At any time while we're talking, any question at all pops into your mind, just type it in. We're here to answer your questions. We're here to make sure that you don't leave with more questions than you started with. We want you to have answers. And I'm going to do everything I can to answer all the questions that are posted. But we're going to start with the most common questions that we get. You might have a personal question that you really don't want to post to the question box, and that's fine. If you want to just email your question directly to us, you can email it to maria@terabellalaw.com, and we'll make sure that we get you an answer to your question. So booking is open right now. Go to my website or go to the booking page, book your life, legacy, and Medicaid family planning session online. Look at your calendar, get it done. And right now, I believe I am ready for questions from Patricia.
Sure, John, can you hear me?
I can.
Great. Okay, so here's some really common questions we get. My mother passed away a few years ago, and my father is now in a nursing home, but did not qualify for Medicaid. Is it too late for me to meet with you and to try to reapply for Medicaid?
It is never too late to meet with a qualified attorney and explore the possibilities, the possible strategies that are available to help your father qualify for Medicaid. Now, the Medicaid laws are complex, but a qualified elder law attorney will be able to determine if there is a pathway to Medicaid qualification for your father. So absolutely, there's no reason to put it off. There's no reason to hesitate. Speak to an elder law attorney and see what possibilities exist.
So my parents were told they would have to give away all of their assets to qualify for Medicaid. Is that accurate?
That is not accurate and may actually cause their Medicaid qualification process to be unnecessarily delayed. Now, Medicaid imposes what they call a penalty period for assets given away within 5 years of applying for Medicaid. During this penalty period, your parents will be forced to pay for their long-term care out of their own assets. So if your parents start giving away assets thinking that that's going to help them qualify for Medicaid, it can actually extend the amount of time that they don't qualify and force them to have to spend more of their own assets to pay for care.
Is it legal for my parents to transfer or to retitle assets in an attempt to qualify for Medicaid?
Absolutely, it's absolutely legal. These are the laws, some of the laws that Congress have given us, that Arizona has adopted, that allow you to transfer or retitle assets. There are absolutely no laws that prohibit the transfer or retitling of assets in order to qualify for Medicaid. However, any transfer or retitling of assets must be done carefully, because you want to avoid that penalty period that I just spoke about, in which your parents would still be responsible for paying for long-term care out of their own assets. So yes, that's definitely going to be part of a plan, but it needs to be done under the guidance of a professional.
So John, how much of my parents' assets can be protected if they have not done any planning in advance?
Well, this varies from client to client, and it depends on the situation, the specific goals and desires of your parents and of the family at large. In general, a qualified elder law attorney can protect 100% of your parents' assets if they are married and both are still living. Now, if your parents are not married, or if only one parent is still living, we can still generally protect somewhere between 40 to 70% of their assets.
My parents added me to their bank account almost 10 years ago. Is the money on that account now protected from having to be spent for a nursing home?
Yeah, unfortunately, the answer to that question is no. The entire amount in a joint bank account is still counted as belonging to your parents, unless they can prove that some or all of the money in that account was actually contributed by you. And this is often extremely difficult to prove. Additionally, there are other reasons that having you on their bank account as a joint owner is not a great idea. Your parents' bank account is now vulnerable to your debts and your liabilities. For example, if you're sued for damages, or you go through a bankruptcy or a divorce, your parents' assets that list you as a joint owner may be at risk to satisfy those judgments or debts. And potentially that could leave your parents absolutely financially devastated.
So this is actually from someone we met with recently, who she said, I'm 85 years old and I live alone. My daughter is in poor health and will not be able to care for me if I become disabled. Should I be considering a Medicaid qualifying plan now?
Excellent question. Now is the perfect time to start planning for Medicaid qualification. Depending on your overall health, a qualified elder law attorney can help you set up a plan that will protect your assets at any time should you find yourself in need of a higher level of care than your family will be able to provide. Now, it's much more cost effective to put that plan in place now than it is to wait until you're in crisis mode. So absolutely, especially your daughter is not going to be there to care for you, and you can foresee needing long-term care or skilled nursing care in the future. Don't wait, start the planning process now.
Should I encourage my parents to go ahead and gift their house to me now so that they can qualify for Medicaid if they need it in the future?
Well, maybe, maybe not. It all depends on your parents' current ages, their health, their prognoses. Now, as an attorney, I would never recommend that anyone take any action until I have thoroughly examined and analyzed their total assets and their ultimate desires for themselves and their family. Also, there are several other criteria that must be considered to even know if their home will be a disqualifying factor. In many cases, we can show Medicaid that they have no claim against the home and that they should not consider the home as a countable resource against the clients. So giving your home to a child or prematurely and without a full thoughtful analysis really could be a big mistake.
Could my parents be forced to sell their house in order to qualify for Medicaid?
Wow. Well, actually, this is a sad but true possibility. Yes, that is a possibility. Fortunately, there are many ways that we can help your parents protect the equity in their home, but the rules are complex and your parents should really consult with a qualified elder law attorney to help them plan for that.
If my parents have too many assets to qualify for Medicaid, can they just start giving them away now?
Well, again, the answer to this question is maybe, but it must be done in the right way and at the right time. Otherwise, they could trigger a significant penalty period that could really harm them, and force them to still have to pay for the long-term care out of their own assets. And if they've been giving away those assets, they may not have that many assets left to pay for their care, and they could still be facing a penalty period. So again, a recommendation is a qualified elder law attorney to help your parents calculate any potential penalty period and plan around it so that they can qualify for Medicaid when they need it.
So, John, I'm not seeing any more questions in the queue. I don't know if that's because we have no more questions or if we're having a technical difficulty, but if you have a question and we haven't responded to it, please do what John said and email it to maria@terabellalaw.com, and we'll get that answered right away. John will get that answered.
Thank you, Patricia. Thank you, everybody, for sticking with us tonight. I hope that after spending an hour and a half with you, that you've walked away tonight with knowing something that you didn't know before, and having a plan in place to talk to your parents, to help get that conversation going about their planning and understanding things that you can do to help prepare them, help them get their finances in order, help them to get their incapacity documents in order, help them get their estate plan done so that they can avoid probate for the family and protect the assets that they pass down. But ultimately, that you have an understanding that they absolutely can plan, and especially the earlier they start, the better, but they can plan to qualify for Medicaid, protect all the assets they've worked so hard throughout their life to save and accumulate, and still get the best medical care possible. And that's just so liberating, I believe, to parents to understand that they don't have to become financially destitute before they can start getting Medicaid assistance. Federal and state law has given us the opportunity to get them qualified and protect their assets. And it's just, again, it's an investment that will save them potentially hundreds of thousands of dollars in the future. So I do encourage you, if you have not gotten on my schedule, go ahead and do it now. If you can't get on, call the office tomorrow, talk to Patricia, 520-428-1188, and we hope to see you soon. Thank you, everybody.